I'll go ahead and get started. Welcome, everyone. My name is Dr. Elena Rios, and I'm president of the National Hispanic Health Foundation. We are very pleased today to have a discussion on the future of diversity-based admissions at public health schools. This is I guess, the explanation, let's say, an overview of the Supreme Court's decision on the use of race-conscious admissions and its impact on public health schools and options for compliance. We do have some housekeeping before I do the talking points. All participant microphones will be muted, but please feel free to type your questions into the Q&A box for the panelist to address at the end of her speech. Please fill out the short post-webinar survey that will be emailed after the event and also shown as a QR code at the end of the slide deck. Recording will be housed on the NHHF website, which is nhmafoundation.org, and sent out 1 week after the event, and will also be on our YouTube channel. Next slide. We'd like to tell you the objectives are to emphasize the significance of the Supreme Court decision in the context of public health careers, particularly public health schools, minority serving institutions, and public health officials who need to understand that the decision does not eliminate the use of affirmative action programs. Number 2 is to provide options for compliance. And number 3 is to develop campaign messages for a call to action campaign to promote diversity, especially targeted at African American or Black, Latino, or Indigenous people in the public health workforce. Next slide. The NHHF mission is to improve the health of Hispanics in the United States by promoting education and awareness, advancing research, and advocating for policies that address the unique health needs of the Hispanic population. The foundation seeks to reduce health disparities and ensure equitable access to health care for Hispanics, and I'll add other underserved. We started 30 years ago as a foundation connected to the National Hispanic Medical Association. We're about to become independent, and we got our first government grant, which is a CDC grant to diversify the future public health workforce, and we're very happy to be able to educate our audience about this important topic of the Supreme Court decision. Next slide. So I have some other talking points here. Let's see. I think what's important is I've already mentioned the program. We know that diversity, equity, and inclusion programs are under fire, but with adversity comes opportunities. And on June 29th, 2023, the Supreme Court ruled to significantly limit the use of race in college admissions, especially in schools of public health. This decision will impact the admissions of minority students into public health schools and reduce the pool of minority public health students to enter the public health workforce. The consequence of this court decision will impact recruitment efforts to increase the representation of Blacks, Latinos, and Native Americans in the workforce of local, county, state, and federal public health entities. I think that we all know from the pandemic, the COVID-19 pandemic will be increased in this country, now knowing how important public health messengers are to educating, especially our most vulnerable communities. The webinar will shed light on how we can comply with the court's decision, but also use other approaches to recruiting underrepresented minority students into public health programs, increasing the pool of public health servants who represents this country's demographic landscape. So on with the program, I'm honored to introduce Dr. Dana Bowen Matthew, the Harold H. Green Professor of Law and Dean of the George Washington University School of Law. Dr. Matthew's accomplishments are extensive, so I will only highlight a few. She joined the GW Law School in August 2020 to become the first woman to lead the law school as dean in the school's 158-year history, and probably the first Black woman. Since joining GW Law, Dean Matthew has overseen the transformation and regrowth of law faculty, hiring 10 tenure-track faculty members and over 100 new part-time adjunct faculty, and overseeing the establishment and launch of 5 new clinics in which students represent live clients unable to afford legal representation in civil and criminal matters, a new health law program dedicated to representing indigent patients experiencing legal barriers to good health, founder and inaugural faculty director of GW's newly chartered Equity Institute, an interdisciplinary research hub that addresses racial, ethnic, and socioeconomic injustice in the United States and globally. Dean Matthews is an innovative and entrepreneurial leader. Before arriving at GW, she served on the University of Virginia School of Law faculty and was also the research professor of civil liberties and human rights. She co-founded and directed the UVA Equity Center, which redresses racial and socioeconomic inequality in the surrounding community. Before her tenure at UVA, she served as professor of law, vice dean, and associate dean of academic affairs at the University of Colorado Law School, where she co-founded and directed the Colorado Health Equity Project. Dr. Matthew is a leader in public health for the nation and civil rights law, who focuses on disparities in health, healthcare, and the social determinants of health. She is the author of the best-selling book, we'll all have to get it, Just Medicine, A Cure for Racial Inequality in American Healthcare, and the recently released Just Health, Treating Structural Racism to Heal America. Dean Matthew received a BA in economics from Harvard Radcliffe College, a JD from the UVA School of Law, and a PhD in health and behavioral sciences from the University of Colorado, Denver. A visionary, energetic, not tired, and strategic leader, I present to you Dr. Dana Bowen Matthew. And Dr. Matthew, we really need to follow up with you. I want to thank you on behalf of the National Hispanic Health Foundation. I know you've met our staff, Guadalupe Pacheco, who's involved with us as a director of programs. Dr. Guillermo Mendoza, who's actually a lawyer. He's our associate director of programs. And Viviana, who's our coordinator of programs, Viviana Garcia. Alexandra Kamler, who's also an MPH student, alumni. She's our consultant on evaluation. So thank you very much. I want to let you go forward, and I'm going to have to sign off. I'm getting ready for a vacation trip and I have to sign off. So I will listen in as long as I can.
Well,
thank you very much.
Before you sign off, let me thank you for that generous and wonderful warm welcome. Thank you, Dr. Arias, so much.
Sure.
Thank you for your leadership. And I want to be formal, but Guadalupe, I just thank you so much. I know you made this invitation possible, and I so appreciate being able to work with you and see you again. Alexandra, Guillermo, everyone who made it possible for me to be with you today. It's an honor. And I'm reminded of an old Negro spiritual that says, I don't feel no ways tired. I've come too far from where I've started from. So I am not tired.
Right.
I'm ecstatic to be with you. Thank you very much.
Thank you very much. And
You're
I'll
welcome.
just cut my camera off, but I'm going to stay on listen. Thank
Very
you.
nice of you. Let me just confess right at the start that I have an agenda and I have an opinion. So I'm going to be very systematic and academic about supporting that, but I'm going to tell you the agenda to start with. I believe, number one, that in the decision that we're going to talk about and center most, that is the Students for Fair Admissions versus Harvard College and UNC, the Supreme Court has reversed 50 years of precedent and has done so wrongly. So I believe the decision is wrong. I will tell you that it's not the first time that the decision coming from the Supreme Court historically has been wrong. And so my second point is I am not dissuaded or discouraged about the ability to continue to stay the course and do the right thing even when the Supreme Court is wrong. That's point number two. The Supreme Court has been wrong in Korematsu. That's the case that approved Japanese internment. The Supreme Court has been wrong historically, Plessy versus Ferguson, Dred Scott, so many cases that I can name. And yet the cause of equality and justice, especially in higher education, I believe is worth preserving and can go forward, notwithstanding the fact that the Supreme Court has made a mistake. And then thirdly, I will tell you again, my agenda is to enlist your help in finding ways to stay true to the cause of diversity in higher education, particularly in public health schools, because I believe it is the right thing to do and the only way for our country to live true to its values. So you can cut off right now. That's all I have to say. And everything else will be in support of those principles. I do have a lot of slides to support those principles, and that's why I wanted to get the bottom line out first. And now I'm going to share my screen and my outline so that you can have a sense of where I am going. I think that you should be looking now at my outline for this talk. Is that right?
Yes,
Okay, and you're looking at just the slide, not the presentation view.
just a slide.
All right, so I'm going to start by talking about how law and public health are integrally intertwined. I'll start with a personal story and then some theoretical support for that principle. Then I'm going to tell you what aspects of law affect population health very directly, because those aspects of the law are underlying the decision. I'm going to talk briefly about how those laws, and you're going to be going to law school for a minute here, so hang with me, how those laws affect population health, and then I'll dive into the Supreme Court decision itself. That's where I'm going to spend the bulk of my time and coming out in the conclusion to the call to action. All right, so the principle I want you to keep in mind, no matter what else I say, is that health is a byproduct of justice. You can tell how healthy a population is by how just it is. And the fact that we have the disparities that we all know affect the Latino, Native American, African American, Native Hawaiian, and other marginalized populations in this country so disparately is an evidence of the fact that justice is not equitably distributed. So what helps with this? My theory is that the law helps with this, and let me tell you why. I'll tell you why by starting with a story about my parents. They are an example of how the lack of everyone having health equity, that is a fair and just opportunity to be as healthy as possible, can result in a premature death and a sicker life. So my father and mother in this picture are 47 and 48. 1 year later, my father is dead at the age of 49. He is dead at the age of 49, not because he's slightly overweight, which he is. He is dead at the age of 49, not because he had comorbidities, that is high blood pressure and a history of heart disease, which he did. But even those comorbidities were a function of what I consider to be structural inequality that affected his life expectancy and my mother's life quality. So what I would suggest to you is that it wasn't just because they are African American, but because where they live mattered to every other resource that was available to them. I'll tell the story briefly by showing you, let's see if I can get to my next slide, showing you a picture that I want to stay with you throughout the remainder of my presentation so that you will understand why my parents' death was not just due to their health, but to the way that their social determinants affected their health. So this is a plane that you know the story of, Flight 1549. It was on its way from New York City, LaGuardia, to Charlotte, North Carolina, when it hit a gaggle of geese. That gaggle of geese caused an engine failure and the plane had to land. The landing was in the Hudson River. The Hudson River was sub-freezing. All 155 souls had to be rescued, but if you look carefully, those people on board in the back are standing on the wing. They're the largest group and they're sinking. Their life expectancy after that disaster in the Hudson River is much shorter than those people in the front of the plane who are in life rafts with life jackets, with food rations, with flares. They have better resources to withstand a disaster. Place matters, not only on the plane, but place mattered for my parents. Why? I grew up in the South Bronx. I went to Public School 93. This is a picture of Public School 93. It is a concrete jungle. And it was a fine elementary school, but it would have fed me into a middle school that actually ultimately got condemned. I would have had to pass through metal detectors. I would have had police officers in the hallways. I would have had a dearth of college counselors. Instead, I would have had security guards, no AP classes, no band, no art, no extracurriculars. The school was a disaster. And so to avoid that, my parents worked 4 jobs for my father and 2 jobs for my mother in order to afford the $4,000 that was their copay to get me to this school. Ethical Culture Fieldston School was a mere 7 miles away. That 7 miles gave me this bucolic, grassy hillside that looks like a college campus. I had ethics classes, dance classes, music classes, every sport, every after-school activity imaginable. College counselors, because this was a college preparatory school, and because I went here, I stand here today before you, well educated and able to be introduced with Dr. Rios's fabulous introduction. So again, place matters. And it matters in every aspect, not just in education, but in housing. My neighborhood in the South Bronx did not, by the time I left for college, have a major chain supermarket. It mattered with respect to the air I breathed and the water I drank, but not just me. I show you my parents' picture and tell you their stories because they are not unique. You know this story. You have seen this diagram. You know that the social determinants of health, the social and economic factors that are responsible for at least 40% of health outcomes, and even health behaviors, which are influenced by social and economic factors, are really the true indicators or predictors of how long and how well my parents' lives and all of those who lived in the South Bronx with me. They had to work 6 jobs between them because there was no living wage being paid for any one of the jobs that they had. That's what we mean by social and economic factors. Now, the part I want to add to this understanding is the fact that unjust discrimination affects most social determinants of health. Housing discrimination, education discrimination. The South Bronx, where I live, has a disproportionate number of trash waste stations. I crossed 3 interstate highways every time I walked to PS 93. Pollution abounds, food deserts abound, so that every one of the social determinants is affected by unjust discrimination. That being the case, my thesis for you is that civil rights law is required as one of the tools, perhaps an underappreciated tool, that will equalize health outcomes among populations in the United States. That's why this Supreme Court decision is so important, because getting civil rights law wrong is also going to allow the unjust discrimination that describes social and economic factors predominantly responsible and determinative for health outcomes that will allow discrimination to flourish. That's the reason why this important decision must be dissected and protected against. So let's look at the law that is beneath this decision. What law affects population health that was a part of this decision? So of course, first is the United States Constitution. And in that Constitution, there are a series of amendments that we call the Reconstruction Amendments. Those are the amendments that were passed immediately after April 9th, 1865, the close of the Civil War. The 12-year period that followed from 1865 to 1877 is called the Reconstruction Era. Hang with me, because the Reconstruction Amendments of the United States Constitution are the bedrock of the laws that were addressed in the Supreme Court's affirmative action decision. There are 3 Reconstruction Amendments. The one that this Supreme Court focused on most was the 14th Amendment. You've heard it referred to before. I've circled the part that was most important to the court's analysis in this affirmative action decision. The amendment, section 1, that I've circled is the language called the Equal Protection Clause. The Equal Protection Clause says simply this. You see the language here, but it simply says that if a state or a county or any public government is using public money, they cannot discriminate under the law against any group. Now, that's the translation of this language. It is not constitutionally permissible for a state actor, a government actor, to deny equality under the law to any group. Now, as a result of that bedrock principle, the United States has several pieces of federal legislation that are called civil rights legislation. These laws are numerous. You've heard of many of them. You've heard of the Fair Housing Act. You've heard of the Voting Rights Act. All of these are a function of, they are a result of the 14th Amendment's Equal Protection Clause. So the second statute that was very prominently analyzed in the Supreme Court's decision is called Title VI of the Civil Rights Act of 1964. Title VI of the Civil Rights Act of 1964. And it says what you expect it to say, that no person in the United States can be discriminated against based on race, color, or national origin. That's the language of the statute that was enacted in order to implement the 14th Amendment's Equal Protection Clause. Okay, so you're with me. We have two sources of law that are important to understanding this decision. The first is the Constitution's 14th Amendment, Equal Protection Clause. The second is Title VI of the Civil Rights Act of 1964. So now you're done with law school. You now get an opportunity to see what the Supreme Court has done with those laws. One more piece of law that's important for you to know before we dive into the decision is the series of cases that preceded the Students for Fair Admissions versus Harvard and UNC. These cases are a long line, starting with a decision in 1973 that said that affirmative action, that is race-conscious admissions, could be used if they were not under a quota in order to achieve educational benefit. Those decisions started in 1973 with the Bakke decision and ended in 2023 when the decision in Students for Fair Admissions versus Harvard and UNC were decided. But before you go to the decision itself, this precursor, right? It comes from a decision that was decided immediately before the SFFA versus Harvard and UNC decision, gave us a very clear prediction. We could have seen this reversal of 50 years of precedent in the SFFA versus Harvard case coming a mile away, because in the decision called Concerned Parents, which reversed a affirmative action program in two cities, Louisville, Kentucky, and Seattle, Washington, Chief Justice Roberts made this statement: the way to stop discrimination based on race is to stop discriminating on race. This was his signal to the court, to the bench, to the bar, and to the public that affirmative action was coming to an end, because his signal said that affirmative action was itself discrimination. That's the underlying principle that is animating the Supreme Court's decision in Students for Fair Admissions versus Harvard and UNC. Now let's dive into that opinion. The decision held that two race-conscious admissions programs were invalid under the 14th Amendment, the 14th Amendment's Equal Protection Clause. It held that the educational benefits of having a diverse admissions policy were no longer compelling enough of an interest in order to allow the Constitution to protect that race consciousness. Now here, let me make a slight detour. I'm happy to do more in the question and answer, but these are all very technical terms. They are technical in that the word compelling interest and narrowly tailored and strict scrutiny, that holding that you see where I say held Educational benefits no longer serve a compelling interest, are no longer narrowly tailored, longer satisfy strict scrutiny. These are very important legal definitions that used to go the exact opposite direction, right? What you need to understand is that for 50 years prior to this decision, what was compelling is no longer compelling. What was narrowly tailored is no longer narrowly tailored. And what used to satisfy strict scrutiny no longer satisfies strict scrutiny. Now you have the reasons, and I'm happy to go into those if you'd like. But at the end of the holding, the majority's opinion dropped down to the last held, right? Held these universities no longer may consider race narrowly, right? The last thing that the court held is why I have at the end of this presentation a call to action to stay the course, to continue to pursue the values of diversity, inclusivity, belonging, because this court also said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. I want you to pause here, because what this court said is that we no longer are going to stand by race-conscious admissions generally, but we will stand by the consideration of race individually. I'm going to say that one more time. The court said we no longer will stand by an overarching consideration of race as a plus factor generally in admissions, but we will allow universities to consider race as it affects individual applicants. This is a very important exception. It is a very important reason that we can still remain hopeful that although 6 justices, in my view, unadvisedly, made the decision to reverse 50 years of precedent, they still have left an opportunity for us to continue to do the right thing and to continue to educate equitably and equally in our schools. So now each decision in the Supreme Court is written by a justice who writes for the majority and a justice who writes for the losing side or the dissenting side. There were several key opinions, even though the majority decision was not written by any of the justices that you see here. If you have time to, in addition to read the overarching decision, I recommend highly, in addition to the one that I am going to speak about in most detail and most depth, that you take a look at each of these for different reasons. Justice Thomas, look at his decision because he has what I would deem to be the most extreme negative perception and opinion of affirmative action. If you want to see how far is far, you can read his decision. He believes that there is no circumstance under which race-conscious admissions would be acceptable, and he dissents from the portion of the opinion that I read last in the prior slide. You'll want to read Justice Gorsuch's opinion because remember that statute that I cited as important to this decision, Title VI of the Civil Rights Act of 1964. It is the underpinning for a lot of civil rights law, the Voting Rights Act, the Fair Housing Act, many civil rights statutes, Title IX, Title X are patterned after Title VI. Justice Gorsuch's opinion is of note because he is coming for Title VI. He's not satisfied just with reversing affirmative action. He, in his opinion, writes to say the court should have reversed Title VI as well. Beware. It is important to see what the court signals as its next move, as it is important to understand what its current move is. And I highly recommend Justice Sotomayor's dissent to you. Now, Justice Sotomayor grew up about 10 blocks from where I grew up. So I consider myself a very, very big fan of Justice Sotomayor. Her opinion was pure, it was art, it was science, it was law, and it was power. She brought the tradition and history arguments that the Constitution should be colorblind to their knees. In other words, that argument of color blindness, one day we're going to return to her opinion because she used the very tools that Justice Thomas used to destroy affirmative action to show how wrong he was. It was a fabulous opinion, and I highly recommend it. But the one I'm going to focus on is Justice Jackson's opinion. And I'm going to focus on her opinion because I believe it is an example of an area of law that I invite you to join me in elevating, celebrating, and beginning to deploy. I call it legal epidemiology. I am not the only one who coined this term. Legal epidemiology is the use of the data that epidemiologists gather to inform the decisions that lawmakers make. Again, legal epidemiology uses the data of public health to inform the decisions of law. And that's exactly what Justice Jackson did in this dissent. She did it beautifully by starting with the law and talking about the race consciousness that used to be protected before this decision, the history of why it was protected, showing the laws like Black Codes, Homestead Act, the Plessy versus Ferguson, Homeowners Lending Act, all of the things that we have seen the law do that actually cause unjust discrimination, right? The historical role that law has played in creating discrimination, segregation, and inequality were the reasons that she argued affirmative action was important. She went on to say that racially blind policies still do harm in society today. She used several examples to conclude the quotation at the bottom that persistent and pernicious denial of what has been done on every state of the union for the white race is why we still need affirmative action. Now, if she had stopped there, she would just be a legal jurist. She would have just done her job as a law analyst, as a law thinker, but she went further. She started with the epidemiological evidence of wealth gaps. She looked at the data that showed the difference between median wealth, whether educated or not, the median income gap. She went on to look at the data that shows the differences in home ownership rates and the disproportionate impact of housing discrimination on evictions and the presence of substandard living conditions. Now, I want to pause here because these data are very important, but you're going to see in my call to action that most of her data has to do with the Black-white gap. This is one of the calls to action. We need to fill the data sets that are necessary to make these arguments with information about Latino, Native American, Asian Americans. These need to be more nuanced data sets so that we can look at these wealth gaps and so that we can do what she did next. She went next to education gaps. Again, fewer Blacks with college education versus whites. Those who graduate, more debt load. Higher likelihood of access to preschool. Higher likelihood of access to staying in preschool. She did the school disciplinarity disparities that begin at 3rd grade. You see where she's going? She is explaining why affirmative action is so important by looking at the social determinants of health that make educational inequality by the time we get to college, public health graduate school, law school, medical school, very predictable. No surprise here whatsoever that we have educational and achievement gaps when the system and pipeline is so filled with inequality. She then went to the health data itself. She talked about elevated blood levels and those disparities between Black and white children. Black and Latino children with heart conditions are 2 times more likely to die than white. This is all in her legal opinion in the SFFA versus Harvard and UNC decision. These are the reasons that she gave for the decision of the majority being wrong. She is talking about the epidemiological data that tells us how likely Blacks are to die from prostate cancer as compared to whites. The difference between maternal mortality rates of Black mothers and white mothers, COVID disparities obesity, hypertension, maternal mortality, infant mortality, stroke. She went through the health data in comprehensive and total ways. And she did this to conclude that the disparities in outcomes of educational performance were entirely predictable given the unjust discrimination in all of these other social determinants. This was the reason I consider her opinion one of the best examples of legal epidemiology. She took the data about health, wealth, education, income, employment, and she explained how it predicted the disparities that were being corrected by affirmative action and would continue to be necessary until we got rid of these other social disparities. It was brilliant, and we should follow suit. So what should we do? The call to action for you to comply with this law, which you must. You may no longer, as a school of public health, identify race as a predictive factor and consider it for the population of any group that you're admitting. But remember what I said earlier. You can consider how race has affected any given individual. I think it is very important for us to be able to understand that the law has changed and it must inform public health school policy, but it doesn't have to inform the public health school values, the public health school's commitment to educating a diverse population. For example, the research that you do can continue to understand the educational disparities and place-based outcomes because you understand, as this diagram suggests, that educational attainment is directly related to health outcomes. Health inequity is a result of educational inequity. We won't go through this slide in detail, but you know that psychosocial environment, work environments, health knowledge, literacy, all of these are affected by educational attainment and ultimately have an impact on health equity. This is your why. This is why research must continue to make this connection. This is why research must make this connection for more nuanced groups so that we can give policymakers the evidence that they need to do what Justice Jackson did in this decision, not just for Latino populations, but for Puerto Rican, Cuban, Salvadorian, South American, European Spanish populations. These are disparate populations with disparate health needs and disparate health outcomes. Our research is not showing it. You can help by improving the research data that we have to work with. You can also help by reforming your admissions and student support standards with the understanding that the law has changed, with the understanding that you are going to receive applicants who are the beneficiaries of an unjust educational pipeline. Your admission standards should also reflect that you are not necessarily looking at narrow quantitative measures, which, no surprise, are disparate by race, ethnicity, and preparation, given the pipeline that I've described that leads up to them. But you can broaden and make more equitable your admission standards without them being expressly race conscious. They can ask the question that the court in the decision said was not precluded. Tell us, please, in your essay for admissions to this public health school, how did race affect your individual experience? How did ethnicity affect your characterization, your character development? How will these factors influence your individual contributions to this school class? Do you see where I'm going? The law has made it impossible to use race as a predictive factor for a group, but you now have the ability to reform your admission standards and your student support standards, recognizing that resources are inequitable to start with, right? Recognizing this is data from public schools that have access to the full range of math and science courses that are important for them to be able to do well on the MCAT, on the GRE, on the admissions tests, right? They're disparate by the time they get to college. your admission standards can be more equitable. And by equitable, let me say, I don't mean equal, I mean equitable, right? I mean that you may adjust your admission standards, your student support services in compliance with the law, but in order to reflect the fact that students from different backgrounds have different level of preparation, not different level of ability, capacity, intelligence, and the ability to really perform well in their careers and to become contributors to the public health in so many ways, but only in their preparation, because our society still distributes, as my parents experience, resources inequitably. Place matters. Place matters, and your admissions and student support services can reflect that. As a public health school, you can use the federal law to use the Department of Education, the EPA, the Health and Human Services Civil Rights Complaint opportunities, avenues, and mechanisms to challenge structural policies that are discriminatory and violate the Civil Rights Act, Title VI, the Equal Protection Clause of the 14th Amendment. There are federal regulatory complaint systems that you can use to bring whole school systems and districts into compliance. I will say I've worked in the federal government. I used to work in the EPA's Title VI office. And one of the departments I admired most was the Department of Education for holding all who receive federal funding accountable to the Title VI prohibition against discrimination. This is another tool. Litigation's not for everyone. Litigation's not for everyone, but you can use litigation in the ways that it has been used to desegregate hospitals, to require equality in school funding, to do the things that could be done only if you force a legal system using litigation. And I can tell you one of the areas of litigation that I think it's most necessary is to close the $23 billion, I said $23 billion gap between funding for schools that serve predominantly white versus school districts that serve predominantly Black and Latino students. Now that's at the K through 12, but you might find those kinds of disparities in federal funding in graduate medical programs and others, and litigation is an option. I put legislative reform together with this picture because I want to remind us of the price that was paid for the Civil Rights Act that some of the Supreme Court is coming for right now. I think it's important that you know that your congresspeople, House of Representatives and Senators, are being invited to reverse Title VI in many areas of the Civil Rights Act today. These acts were paid for by people like those that were attacked by dogs. You've seen the hose pictures. You've seen the Bloody Sunday march across the Edmund Pettus Bridge. You've seen the cost. Therefore, you're pursuing legislative reform by writing, either in your individual capacity or as a school, to preserve these civil rights statutes is important. And lest you think it's not your problem, let me say that the way we got these civil rights statutes was because medical professionals marched and advocated, sued and argued to enforce, to pass, and to bring these legislative opportunities, these legislative statutes to us. So you are an advocate, and when you see civil rights as part of your responsibility, you will definitely, in my view, have heard my message that health is just a byproduct of justice. Now, if none of this is for you, you don't want to sue anybody, you don't want to file a claim in the Department of Education, you don't want to march, you don't want to yell at your congressperson, just be careful how you vote. Please make sure you vote. Not just for your own pocketbook, but think about the discrimination, think about the injustice, think about the environment, food insecurity, housing inequality, educational inequality, and vote like other people's lives matter. It does make a difference who you vote for. Now, for those of you who really want to go all the way, we can talk reparations during the Q&A if you'd like, because I think that's yet another important discussion that we could talk about. Much more complicated, much more nuanced, but I'll end by saying thank you very much. for the opportunity to suggest to you that we're all in this together. I always end with this slide because it is a stand of redwood trees that individually look as though they are one in their own right, each one individually, but underground they are connected, as we all are. Thank you very much for the opportunity to be with you today.
Dean, this is Guadalupe, and this is the second time that I've heard you speak, and it just gives me more hope.
Thank you so much.
You know, laying some specific strategies to address the consequences of this decision. And I always tell people sometimes challenges present opportunities. But also if we look at history, and I think you kind of laid out the beginnings in terms of the oppression of a particular, you know, especially African Americans, and even if you look at Mexican Americans in Texas, they were lynched at the almost the same rate
Absolutely.
that blacks
Yeah.
were in the southern states. But we need to look at history and how we deal with you know, civil rights decisions, because you know they give us hope, you know. And so again, I want to thank you for providing an outstanding kind of presentation. What I'd like to do now is just open it up for Q&As. But before I do that, I mean, you talked about place does matter, and I think that is so true. I grew up in California, a little town called Riverbank, which is 10 miles east of Modesto, and it was a segregated little town. The railroad tracks were the dividing line. So you had Taco Town on one side, you had the Okie Town, but it's Dust Bowlers, and then you had like a neutral zone.
Wow.
But my dad made a strategic decision to move us out of Taco Town into this neutral zone where the school was literally 2 blocks away. There was a swimming pool, again, a half a block away. There was a recreational center a block away. And it made a difference because I have 8 sisters and there's 3 brothers, there are 11 of us, all graduated from high school. Some of them went off to college, like myself. I had a retired sister who was a nurse, sister went to Harvard. So it's like place does matter.
Yes.
You know?
Yes.
And,
Yes.
and so you were talking about social determinants of health. That is so on target, because if we don't address social determinants of health, we're not going to make progress. So
That's right.
so let me see if I think I have one question here. She says, this is Matthew Penn. He says, what are your thoughts about relationship among legal epidemiology, the 14th Amendment, and the shift from predatory versus victim perspective on our civil rights laws?
I think, and I want the questioner to tell me if I've taken their question in the wrong direction. I think the query comes from someone who's read Alan Freeman's article about victim perspective versus perpetrator's perspective. Our laws, Freeman argues, are written from the perspective of the discriminator. They're interpreted from the perspective of someone who has not experienced discrimination. That is exactly what happened in SFFA versus Harvard, and exactly what happened in Parents Concerned, the decision that I argue predicted SFFA. Only a person who's never been discriminated against would say something that, like what Chief Justice Roberts said. The way to stop discriminating is to stop discriminating, right? Because that suggests that at the tip of the iceberg, we could make a difference all the way down to the ocean floor. If we just close our eyes to the 400 plus years of historical discrimination and take away color conscious or race conscious admission today, without any correction for the disparities in arrest rates, in educational attainment, disparities in housing, the discrimination that for generations has made our Black and brown populations live sicker and die quicker. We're just going to ignore those, and we're going to go to the tip of the iceberg, the last bastion of discrimination, which is to choose by race to make up for the other underlying discrimination. That is a perpetrator's perspective. That is a misunderstanding of what it means to actually have experienced discrimination throughout generations, right? Guadalupe said his father moved from Taco Town to the neutral zone, right? In order to get into a school that would allow his family to boast that every child graduated from high school. White families that lived on the other side did not have to move. They owned their houses with the help of the GI Bill. They did not have laws such as, there was a vagrancy law in California that was directed specifically at Mexicans. Nobody else was subject to the you can't stay on the street after this hour, right? Those are impacts, historical truths that people who have experienced discrimination realize are not gone. The effect of them remain. And just simply saying we're no longer going to do race-conscious admissions is the perspective of somebody who does not understand history and its impact. So my answer to the question is that most of the interpretations that we're looking at today are from a perpetrator's perspective and do not understand or take into account the lived experience of those of us who are at the receiving end and continue to be at the receiving end of the sequelae and fallout from a racially discriminatory system.
Got a couple more questions here, Dr. Matthew. Can you share more about medical committee for civil rights?
Yes, yeah, I certainly can. The Medical Committee for Civil Rights was later renamed the Medical Committee for Human Rights. It was a broadly inclusive. By that I mean clinicians were nurses, ancillary providers, physicians, a broadly inclusive group that really advocated strongly for civil rights laws. And in my opinion, I'm not the only historian. There are historians who believe, I'm not a historian, but there are historians who back me up on this. In my opinion, we're not only the reason that we got the Civil Rights Act of 1964, because it was really, the impetus was hospital segregation behind that act. Desegregating hospitals was the reason these clinicians were so active in the civil rights movement. But it was not only that they got the statute passed, but the Medical Committee for Civil Rights did incredible work enforcing the Civil Rights Act. So let me make a little detour and then come back to them for a second. When we passed Brown versus Board of Education, the schools in the South didn't say, yay, yippee, we're now going to desegregate. They absolutely went into massive resistance, right? They closed down, they rezoned, they did everything to avoid obeying the Supreme Court law, right? So the same was true when the Civil Rights Act of 1964 was passed and demanded or required hospital desegregation. The Medical Committee for Civil Rights, going back to answer the question, was active in doing what are called inspections and reports, so that any hospital they inspected, they could report for having failed to desegregate, and then the threat of losing reimbursement under Medicare and Medicaid made those hospitals come into compliance. So this was a long campaign, several years. There were 7,100 some odd hospitals in the United States. They didn't overnight desegregate just because Title VI was passed or just because the Supreme Court said they had to. The Medical Committee for Civil Rights was key in going from hospital to hospital, state to state, making sure that that law was enforced until the law became a reality on the ground.
Thank you. There's another question about the military. I think they were exempt
Yes,
from this decision.
yes.
Can you give maybe a rationale why they took that position?
Oh my gosh. Uh, uh, let me say, I think it was a tactical move, because if you read the briefs that were in support of affirmative action, they came from corporate, university and higher education, and they came from the military, and all of them said essentially this: we can't do our job without affirmative action. We can't do our job because we're trying to, in the corporate sense, we're trying to serve a global economy, and we can't do it without the perspective of people from various backgrounds or in the educational setting. We can't do our job educating people to be leaders, to address some of the most pressing problems of a pluralist society without making sure that in our classrooms we have people from all backgrounds. Well, the military argument was the same. We can't do our job, we can't protect the country with a segregated Army, Navy, Marine Corps, Coast Guard. And unless we have affirmative action, we're going to go to segregation. The Supreme Court had to say okay to the military because their job is protecting national security. And that was essentially a nod to the fact that all of those sectors of the economy, which said they could not do their job without diversity, the Supreme Court could ignore, but not the national security argument. It said it was, I think, a strategic move in order to mitigate the challenges to the decision, and that's why I think the military was accepted.
Good, thank you. Here's another one, another question. I understand the use of essays to assist, but how do we get admissions committees to be comfortable with allowing the individual discussion about race impact their decision-making? Seems like they all need intense education about this decision and
Yeah,
its
they do.
nuances.
They do. First of all, you tell them they're following the law, right? So the law of the opinion expressly says nothing in this opinion should be construed to prohibit universities from considering an applicant's discussion of how race affected. So you first say the law, in compliance with the law, we can do this. The second thing you do is look at how other schools have done this, right? There are some really exemplary schools that have taken this language and retooled their application so that it asks exactly what this decision permits a university to ask. Now, right after the language that I've quoted, the Supreme Court's decision, Chief Justice Roberts says, now you can't just fake it. You can't use your essay as a way to get around the law and do what the law prohibits you to do, right? So the important difference and distinction that I have made, and I encourage you to consider making, is individualized consideration versus group consideration, right? So any individual, you can ask any individual applicant to explain how discrimination, how race has affected has inspired them. So you can ask a question that invites an applicant to talk about the fact that one of the reasons they have such perseverance and great study habits, their work ethic is so high, right, is because they come from a family of immigrants. And the family of immigrants had to work so many hours and so many jobs. That's the second thing I will say. The other thing I will say is that you can look at the experience in California with Proposition 207, I believe it is. So there is another way, yes. I think I'm going over in time. This will be, I'll make my answer really short here. I just got a knock on my door. There's another way in which affirmative action has been assailed, and that is by referendum. And Proposition 207 in California was a referendum that forbid California schools from having race-conscious admissions. For a long time, the medical school saw a decline, in fact, plummet in the number of Latino and African-American applicants that were admitted to medical school. But what they did was they changed their application structure so that they were looking for people who had overcome adversity, who wanted to serve underserved neighborhoods and patient populations. They designed their questions so that they attracted people who were of diverse backgrounds. And this is another strategy. So I would say studying the strategy of other schools that have used this language and used other tools to continue to do the right thing, to educate a diverse population so that we can address health disparities, the most pressing challenge of our time. Thank you so much.
Can I just ask just one more question, all right? In terms of, let's say, a call for action to kind of confront this decision, this Supreme Court decision, what would you recommend? Just a couple of thoughts on a messaging.
Yeah,
Messages.
I think the most important thing is that you continue to educate a diverse population. So the call to action is to make sure you reform your admissions processes so that you can continue to admit and educate people of diverse backgrounds. Don't lose any ground whatsoever in the number of people that you're educating from broadly diverse backgrounds. Whatever you have to do, don't cave on the diversity mission admitting students to public health schools of higher graduate schools. Secondly, I think it is extremely important that you don't cave. You find ways to continue to diversify faculties so that these faculties can produce the kind of research and arguments, can become advocates along with partners in the law. It's going to be faculty that do the research and provide the data. It's going to be faculty that become members of the kind of advocacy groups. So making sure that you have diverse representation on your faculty. So those are the two most important things. And please don't vote for people who are against affirmative action. That's my call to action.
Thank you so much for
Thank you so much.
inspiring presentation.
Have a great day and thank you again for having me.
You're welcome. Alexandra, can you jump in now and maybe take over in terms of the messaging that we're looking at?
Yeah, absolutely. Hi, everybody. My name's Alexandra Hamler. I work in the Center for Evaluation and Applied Research at the New York Academy of Medicine, and I'm serving as a consultant on this project. And this part, we only have about 9 minutes, and this is a little bit unorthodox, but we do believe that it would be important for this conversation. As Dr. Rios was explaining earlier, part of the Workforce Development Project that's being funded by the CDC is really to increase the diversification of the public health workforce. And part of that is increasing awareness of public health careers. In order to do that, people need to be trained in public health. And in order to do that, they need to go to, well, oftentimes they're going to public health schools, higher education. And so what we're trying to understand is if we were to have a call to action campaign to increase awareness with the intention of promoting diversity among Black, Latino, and Indigenous folks in the public health workforce, how can we frame some of the messages that we heard today? So you'll get these questions in a satisfaction survey at the end, but we were hoping to engage the audience here. You can put it in the chat. You can do it as a Q&A. You can raise your hand, but really thinking about from you all, from your perspective and lived experience as folks who are interested in this topic, who are working adjacent to or in the heart of this topic, what you think are the main myths that still exist among colleges and university admissions offices regarding this decision, and how we can communicate messages most effectively to provide accurate information to still engage a diverse student body. I know that was a lot of information at once.
Yeah, and they can put their questions on the Q&A or here.
Yeah, so I see Sandra Calderon, you say get advanced degrees. I'm getting a PhD and my research is looking at increasing Hispanics in nursing. I think showing up and letting students see you. Okay, so thank you, Sandra. So that seems to be like what you're talking about is part of kind of changing the culture of the institution that you are at. So shifting what it looks like and what people are engaged in and the focus. I'm wondering for folks a little bit earlier on in their careers, before they get to a public health school, how do we communicate for admissions offices who are looking for a diverse student body? How do we take the messages that we learned today and put them into a campaign? How do we frame them best? From your perspective, what would you say? So Sandra says going to high schools, middle schools, and talking to students about these careers is one step. That's great, right? Okay, so kind of getting out there. So both the awareness campaign is like, it can be digital, but it's also kind of in person, telling people, engaging with them and letting them know the information that was shared today. And then Jaime talks about encourage early career medical providers to participate in their admission committees. Oh, yeah, okay. So thinking about who's on the committee that's reviewing the applications to understand, are there broader perspectives that should be considered. Paulina says diversify medical committee members. So kind of a similar suggestion, really thinking about who is part of that yes/no process of admitting somebody or rejecting somebody, so that it's a little bit more reflective of the type of community you're hoping to build out. And then Joanne says, many are out of the running based on high school coursework not satisfactory for college attendance. Early engagement is key. So Joanne, I'm wondering if there are the engagement, would you say that would be like going to high schools and middle schools and talking to students about the possibilities of a career in public health and what's needed to do that? Or is it looking at how students might navigate a somewhat constrained environment that they're working within, recognizing that the coursework may not be satisfactory? So any additional, okay, so you say yes, and mentorship. Okay, so I love that mentorship is being brought up as an important step in also guiding people towards a career in public health. And Paulina says role modeling and peer mentoring programs. This is great. And I know actually then NHMA has a mentoring program that has shown to be quite effective. And there's so many things in the chat right now. This is wonderful. So Russ Bennett says, NHF is planning a program to educate and create awareness in medical students in clinical comparative effectiveness research, patient-centered outcomes research. Incredible. Noreen says, I think a broader voice and network affirming that all health career paths are possible, starting at K through 12. I think this message is getting lost on students when large systems and contradicting systems or legislation direct students to vocational education or certifications versus higher degree attaining education. So thinking about which students are being directed to which careers and why, and trying to break down the implicit potential biases that are part of that steering process, so that we really are giving students of all backgrounds and diversities the opportunities that are available, and not just the ones that certain people think certain groups should be part of. Delmina, and I apologize if I mispronounce your name, says it should be ingrained in the mission of the organization first. Leadership should be supportive on the time it takes to recruit and retain diverse students. It should be in each department's strategic plan, faculty and staff professional development goals. Also not stopping at diversifying the profession, looking at inclusive teaching practices and support systems for diverse students. Those should be free and available to all students. Counseling services, disability services, well-being services, financial services, etc. We want to ensure diverse students are successful and feel a sense of belonging. This is really interesting because, these are all interesting, but what I'm hearing from you here is there's a recognition of, if diversity is our value, how are we going to make it clear from the leadership down, and how do we embed it into our policies and practices and wrap around services that recognize the lived experience of the diverse student body, so that the default culture that may or may not have been built for a diverse student body, those students are still able to get everything that they need within that culture to ensure that students are successful and feel a sense of belonging. Jaime also talks about mentorship again, this path. This makes the path easier for trainees to follow. Joanne also mentions that she's spoken with First Gen in medicine groups, and just talking about the role that self-doubt plays oftentimes alongside passion. Lisa talks about encouraging health integrative systems to invest in pathways programs and placing project managers to track data. In California, Kaiser Permanente has Hippocrates Circle program targeting middle school students in each region. So maybe that's something for us to look into to see how they are messaging their program to those students. And Sandra says a sense of belonging is huge. I've seen that in my own study now. It can make or break student success. So I wonder, just lastly, I think we have like 60 seconds.
Well,
If there are any
yes.
final, just recommendations around framing, are there specific messages? Because these seem to be really wonderful, opportunities for intervention and programming. And I'm wondering with with an awareness campaign, are there any particular ways to frame the message or any particular content that should absolutely be included so that students know this is a place for you. These are the ways that you can participate. These are the ways that you can still show who you are and all the different experiences that have affected you. Sandra says a slogan like "You belong here." That's
Great.
yeah, that's like concise and clear.
I
Absolutely
have one that says, see yourself in health.
amazing.
So, but Alexandra, I think we need to sign off because we're out of time.
Yeah,
And I just
absolutely.
want-
Thank you
I
all
just
so
want-
much for your
thank you.
participation.
I just want to thank all of you who participated in this webinar on behalf of Dr. Reels and the rest of the team, and appreciate all your input. And we have a QR code that you can also complete for evaluation purposes. So again, thank you so much, and I hope you enjoyed Dr. Matthew's presentation on the Supreme Court decision on, let's say, eliminating race as a criteria for admissions into colleges and universities. Again, thank you and enjoy your weekend. Alexandra, thank you.
My pleasure. I think
Good
we're still
job.
recording.
Oh.
So I don't know if I feel like